The field of medical malpractice is one of the most specialized areas in the practice of law. Medical malpractice cases are among the most complex and difficult cases, and there are not many lawyers who handle these cases on a regular basis. With us today is a medical malpractice lawyer, David Farnbauch. David, glad you could spend some time with us today to talk about medical malpractice.
It's great to be here today.
David, let's start with some of the basics. Can you explain to the viewers what's meant by the term medical malpractice?
Well, the term medical malpractice really means that a doctor or a hospital or some healthcare provider provided care that was below what is known as the standard of care. And the standard of care is the level of care or expertise that is expected to be provided by a particular medical provider in that profession.
David, what are some of the more common types of medical malpractice you've handled over the years?
Well, I think some of the most common types of medical malpractice that we see in our office are cases that involve the failure to diagnose a particular condition. Oftentimes there are problems that are revealed in tests, x-rays that are taken, or studies that are done that reveal that there's a tumor or a problem, and that report is given to the doctor, and the doctor never relays that information to the patient. So there's nothing done to follow up on the treatment after that condition's discovered in the imaging studies or the tests. And then later on, a person develops cancer or a serious problem that could have been treated earlier. And so there's a claim brought against the doctor, the medical provider, for failing to diagnose the problem earlier. Another common type of a medical malpractice case would be a case where a surgery was performed and the surgery was not performed according to the standard of care, and an injury results.
If one of our viewers believes that they've been injured or harmed as a result of medical malpractice, what's the first step?
Well, I think the first step is to contact a lawyer or a law firm that specializes in handling medical malpractice cases. What's usually involved after our office is retained to investigate a medical malpractice case is that we get all the medical records that surround a procedure or medical care and treatment that was rendered to a patient, and we provide those records to another doctor or a specialist in that field of medicine to analyze whether there's been medical malpractice involved in the care.
David, if a person believes they've been the victim of medical malpractice, does it cost them anything to have your law firm investigate the case and decide whether or not it's worth being pursued?
No, it doesn't cost anything. We handle medical malpractice cases on a contingent fee basis, which means we never charge the client any fee unless there's a recovery by way of settlement or a verdict in the case. So it's not going to require the client to pay us any money to investigate the case. If there are expenses involved in hiring expert witnesses to analyze the medical records and determine whether there's been a breach of the standard of care, our office advances those expenses on behalf of the client.
If it is proven that a doctor or hospital committed medical malpractice and caused injury or harm to a patient, what types of damages can be recovered in a lawsuit?
Well, in medical malpractice cases, it's much like any other type of a personal injury case where damages can be recovered for the injuries themselves, for the physical pain and mental suffering caused by those injuries. If there's medical expenses to treat the medical malpractice, those damages are recoverable. You can recover lost earnings if you missed work, or if your ability to pursue a career are damaged or impaired by the medical malpractice, we can recover damages for future lost earnings. If there's a death as a result of the medical malpractice, we can recover damages for loss of love and companionship for the family members who've lost a loved one.
Dave, are there time limits or a statute of limitations that would apply for filing a medical malpractice case?
Yes, there are time limits for filing a medical malpractice claim. In Indiana, a medical malpractice claim has to be initiated within 2 years of the date of the negligent act or the malpractice. So it's important for people, if they believe that they or a family member have been the victim of medical malpractice, to contact an attorney as soon as possible after the alleged malpractice event so the investigation can be conducted before the statute of limitations expires.
Dave, you've given our viewers some very good information about medical malpractice. Thanks for taking the time to speak with us today.
It was a pleasure spending time with you today.